Hello, my name is Michael Tesoro, and I prepared this video presentation entitled Albanese Antitrust, What to Expect from a Labor Government in Competition and Consumer Policy. Bit of background about myself: I'm a competition and consumer lawyer, and I run my own practice, Tesoro Legal Consulting. Been doing that for 14 years now. I recently had my 14th anniversary, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, and I was director in relation to enforcement, also mergers and asset sales, GST. I also ran a few secondary boycott cases. Now, that on the presentation, I'll start with the introduction, then talk about the relevant personnel who will be in the hot seat in terms of competition policy in the Labor government, talk about the Labor policy which they brought to the election in relation to competition and consumer law areas, discuss a few key areas which I think are going to be a focus for the government going forward, and finish with some conclusions. First thing, I'd like to acknowledge an article which I did see by Philip South from Kingwood Mallisons, entitled "A Bigger Stick, Labor Party Promises Changes to the Competition and Consumer Act," which sought to outline the major changes which may be brought in by a Labor government. So I thought it was a good article, commend that article to you. Sought to just take it a little bit further, focusing on the things that are going to be on the Labor government's agenda going forward in the next 12 months. First thing is who's going to be in charge of the relevant portfolio, and it's likely to be Andrew Lee, who was a shadow assistant treasurer who had responsibility for competition policy. So he's got an interesting background, Andrew. He was formerly a professor of economics at the ANU, but he also has a PhD in public policy from Harvard and a law degree from Sydney with first class honours. So obviously he has a lot of expertise in law and economics. He was actually the associate, or one of the associates, for Michael Kirby when Michael Kirby was in the High Court. So he's obviously a very smart lawyer. And I think the interesting aspect of Andrew Lee is some of the books and articles he's written. So there's a list there of some of them: Disconnected in 2010, which is about the way community is becoming much more disconnected. And I think there's an element of the influence of social media, but also a lot of articles and books about inequality in Australia between, obviously, wage earners and corporations, concerns about market concentration, that markets are becoming much more tightly held. Also looking at issues like common ownership of competing firms. So that's a recent research paper that was focusing on the ownership of the large superannuation funds of competing businesses in the Australian economy. So I think there's a strong belief that Andrew Lee is convinced of the problems that exist in the Australian market in terms of concentration, in terms of inequality of incomes. And I think it's fair to say that he does see competition policy as being an instrument by which some of these issues can be addressed. So it's very much part of the New Brandeis movement, or the hipster movement, in terms of using competition policy to achieve a broader range of social outcomes. So I think we can expect a much more interventionist role by Andrew Lee and the Labor government going forward to deal with a lot of these issues that have been identified in these publications. And clearly a big focus going forward will be on measures to curb the power and influence of digital platforms. Now, as I said earlier, there weren't very many policies which Labor brought to the election. There's three that I was able to identify. First was to increase the maximum fine for competition breaches from 10 to 50 million, establish a super complaint function, and also to push through the changes to the unfair contract terms. And there's some links to the actual policy documents that you can have a look at. Not very long. Now, the increased penalties has to be understood in the context of the current regime that applies for competition law breaches. And it currently is escalating system where it's either 10 million or 3 times the benefit that was derived by the company from their illegal conduct, if that can be calculated, or 10% of turnover, whichever is highest. So clearly $10 million doesn't really apply very often if the company's turnover is large. So the company turnover is over $100 million. The $10 million threshold won't apply. But the proposed changes by the Labor government is to introduce or replace the $10 million with $50 million. So as you can imagine, the $50 million becomes sort of the starting point for penalties, and then companies with turnovers of over $500 million will start being looked at in terms of 10% of turnover. So there's no doubt that this change will have a very big impact in pushing up penalties under the Competition and Consumer Act for competition law breaches, and a very clear guide to courts that they really have to be looking at much larger penalties going forward. The second one is to bring in the super complaint process, and I think it's very strongly based on the process that applies in the UK. And in that regime under the Enterprise Act, various organisations can be designated or approved as super complainants, and they've got a power to issue a complaint to the various consumer or competition agencies and have that actioned as a matter of priority. And as you can see there in the Enterprise Act, it talks about being able to raise concerns about any feature or combination of features of a market which are likely to significantly harm the interests of consumers. And it can actually relate to not only conduct, but also the structure of the relevant markets. And it's a controlled process because only the Secretary can determine which companies are designated. And currently there's a number of designated, 3 examples there, which National Consumer Council and Energy Watch. And the Labor government has indicated that with this super complaint process, it's likely that Choice will be designated. Now, I think it's fair to say the ACCC really doesn't like the super complaint process. I think primarily it believes that it's good enough at prioritising imported cases and doesn't need this additional function. But I think the main benefit from a super complaint function is that it will be a very public process, and the ACCC will be forced to investigate the complaint very quickly, and the decision that the ACCC makes whether to take some enforcement action or not will be public. It'll be very transparent. So I think that's a good thing to give consumer groups more ability to bring issues of concern to the regulator's attention, but also that there's a public and transparent process. The third policy that was brought to the election was to fast track the changes to the unfair contract term laws. And this is an issue that had bipartisan support, but for some reason the legislation went into Parliament at the end of 2021 and just stalled and didn't make it through. So the Labor government's going to push this through quickly. And there are a few significant changes in the draft legislation. Firstly, they'll be changing the definition of what a small business is. Currently, it's 20 employees or less. That'll be increased to 100 employees or less. So as you can imagine, that's a 5-fold increase in the number of employees that will define a business as a small business. So a lot more businesses will be caught by that expansion of the definition. Also, there's current contract value threshold. So a small business contract can't be for more than $300,000 as a one-off or over $1 million for a multiple year contract. That's going to be totally removed. So effectively, there won't be any contract value threshold which needs to be met under the new laws. And finally, the use of an unfair contract term in a contract will be illegal and subject to significant penalties. So at the moment, unfair contract terms are void but not illegal. So they'll be made illegal and subject to very large penalties of $10 million, 3 times the benefit, or 10% of turnover. So these changes are going to be very significant. There's some other associated changes, but that's the key changes that will impact business. And I think we can see this legislation probably coming through in the next couple of months. Another big issue for the incoming government is in relation to digital platforms. And so what's happened, the ACCC released a discussion paper earlier in the year, which was outlining some of the problems that they identified in relation to digital platforms and outlining a number of solutions to these particular problems without committing itself to any resolutions. And submissions could be made to the ACCC by the 1st of April about this discussion paper, and the ACCC is currently going through the submissions, working out the various views about ways of better regulating digital platforms, and it will be providing the Treasurer, the new Treasurer, with a report in September with a range of specific proposals. Now, in the report, there's this very helpful roadmap which says that, well, outlines the way the ACCC approached the task. Firstly, it talks about the problem of concentration, the growth of these particular digital platforms, the role they have as a gatekeeper who is in the middle between business and consumers, and they're very influential. Also talks about the harms which they believe that the digital platforms market power is having on both competition and consumers. And then they talk about the history of competition and consumer law enforcement in Australia in this digital space, which hasn't been a whole lot, although the recent enforcement has been quite successful in terms of the ACCC winning those cases. But the main concern is that they believe, the ACCC believes, the laws are a bit too slow and cumbersome to really address the concerns about digital platforms conduct, which are very quick, fast growing markets. Then they outline a range of potential regulatory tools which could be considered to curb the market power of digital platforms. They're talking about outright prohibitions on the conduct that the platforms are engaging in, for example, maybe a prohibition on self-preferencing, the idea of introducing specific codes of conduct to require the digital platforms to avoid certain conduct, say, for example, the use of dark patterns in their architecture. Also looking at rulemaking powers, so maybe at the ACCC or another new regulator having the power to actually set rules for digital platforms, as happens in the energy market. Also looking at ways of promoting competition, and that's obviously issues like transparency, interoperability, and also throughout the idea of an access regime. So effectively treating digital platforms as essential facilities and requiring them to give access to competitors. So as you can see, there's potential new measures that have been put out there for comment. They obviously want to prevent anti-competitive conduct, address issues that are arising in relation to data, and this is a concern that the access to vast amounts of data could be increasing barriers to entry. I believe there are a number of things going on which are damaging consumers, particularly dark patterns, but other types of conduct which is causing unfair outcomes. The concern that the digital platforms are gatekeepers and can really control the access of smaller companies to consumers. So they believe that some fair dealing obligations may be needed. Increased transparency is a goal which needs to be addressed in terms of not only the algorithms, but also the way that ad tech markets work. And then finally, looking at acquisition. So ACCC is very concerned that these digital companies are acquiring a lot of businesses, particularly nascent competitors who haven't really established themselves yet, the idea of the killer acquisition. So that's the report that is going to come out in September, and it'll be very interesting to see how the Treasurer responds to the range of proposals put forward by the ACCC. The other big issue is merger reform, and the ACCC got together with the German and UK competition regulators to issue this joint statement in April 2021, where they just highlighted the challenges they're facing in opposing mergers, the growth of concentration in markets, and effectively saying that there has to be a new approach to merger regulation. Then in August, Rod Sims issued a more detailed set of proposals in his Law Council address, where he specified the types of things which the ACCC are going to be putting to government. And he indicated quite clearly the main driver of this range of proposals is the number of cases that the ACCC has lost in the last few years, listed there, which they believe should not have been let through by the courts. So obviously they believe there's a problem in the way they're able to prevent mergers which are anti-competitive. Now, the merger reform proposals are probably three major areas. Obviously, a formal review process. So the current system's informal, it's non-suspensory, so people can tell the ACCC about a merger, and if they don't get a tick, they can just complete, and the ACCC is forced to go to court. So they want a system that's similar to every other jurisdiction around the world, where it's a formal system and it's suspensory. So the parties are not permitted to complete the transaction until the regulator's finished its assessment of the merger. Also, they want changes to the merger test, particularly to the substantial and competition test. They want that lowered quite significantly to make it obviously easier for them to stop mergers, and specific changes in relation to digital platforms. So a separate sort of merger regime applying to digital platforms. Clearly, the straightforward changes would be updating the merger factors to include new factors in relation to, say, data, privacy, issues like that. That would be fairly uncontroversial. Changing the definition of likely in the merger legislation is quite controversial. It really wants to lower the bar significantly there. And the question is whether that would actually catch a lot of pro-competitive mergers. Also talking about a deeming provision for digital platforms, that they would be deemed to an acquisition will be deemed to lessen competition unless they could prove otherwise, which is very controversial. And looking at tailored tests for digital platforms, so lower thresholds, reverse onus of proof, and things like that. So it's a wide range of proposals that are being outlined. I think it's fair to say that when these proposals were put to the former Treasurer, Josh Frydenberg, he was very uninterested in the whole area, but I guess that's likely to change now. I think these proposals are likely to get a much different reception by a Labor government, particularly given Andrew Lee's comments on the problems of concentration and inequality in the Australian economy. Now, another issue that the Treasurer is going to have to deal with is the news bargaining code. And the background to this is interesting. Initially, it was going to be a mandatory code. Two companies were going to be designated, namely Google and Facebook, and they would be forced to go into arbitration with producers of media content. However, a deal was done at the last moment where these companies were permitted the opportunity to enter into contractual arrangements with various publishers to pay them money for their content. And Google entered into contracts with effectively everybody, and Facebook did contracts with everybody except two fairly significant publishers. So by doing that, the two companies are likely to have avoided designation. However, the problem was that Facebook has refused to enter into deals with two fairly significant news outlets, namely SBS and The Conversation. And recently, Rod Sims has been saying, in his capacity as the former chairman of the ACCC, that Facebook and Meta should be designated under the news bargaining code because they have failed to enter into deals. And if that happens, they'll have to go into an arbitration process with these publishers and have a deal imposed upon them. One issue that's really interesting in relation to coalition and Labor governments is what happens with secondary boycott laws. Currently, secondary boycott laws are contained in the Competition and Consumer Act, and what tends to happen is one of two things. Either a Labor government will move the jurisdiction for the enforcement of secondary boycotts out of the ACCC and give it to, I think in the past, the Department of Industrial Relations, and effectively nothing occurs, or alternatively, the jurisdiction stays with the ACCC, but nothing really happens. And I remember under the Rudd Gillard, when they were in power, I don't believe there were any secondary boycott cases taken by the ACCC. It was just an area where the ACCC did not take any interest. And obviously, when coalition governments are in, there's a lot more activity in this area. So it'll be interesting to see what happens there. I think probably it won't see the jurisdiction being moved out of the ACCC, but I can't see there being a lot of activity in that area by the ACCC in the next 4 years. The other thing that the Labor government has committed to doing is to abolishing the Australian Business and Construction Commission, which was set up to investigate conduct, largely secondary boycott conduct in the construction industry. And so the Labor government's committed to disbanding that organisation, which means that there's a lot of people going to be out of job very shortly. Now, there are a few things I think the government should consider in going forward. It hasn't really outlined a very detailed policy in relation to competition and consumer law matters. I think it needs to do that as a matter of urgency. But I think the area that needs the most urgent attention is the criminal cartel provisions. I think we saw with the ANZ cartel case that the provisions are effectively impossible to establish in a contested hearing. The case was kicking around in a committal process for a lengthy period of time, and then the DPP were unable to prepare a valid indictment despite trying for 3 years, and the case was withdrawn. So these laws are not going to work. They need to be redrafted. They need to be simplified, and I think that's a real priority for the Labor government. They need to commission a review, probably from somebody in another jurisdiction, maybe the US, and then redraft these provisions. The second issue is a general safety standard, which was a very dear issue to the former chair, Rod Sims of the ACCC. The idea that we don't have a general obligation on business to provide goods that meet minimum safety standards is quite remarkable. It's a law that exists in a number of other jurisdictions, and so that'd be a priority to push that forward, I think. Also, the previous chair was very keen to push for an unfair methods of competition law, similar to the Section 5 of the Federal Trade Commission Act in the US. And there's been a lot of discussion about this, but no real action. I think it'd be good to just commence a process of reviewing what this would mean, thinking through the problems it's seeking to solve, and then coming to a final conclusion whether to bring it in or not. The other two things that I think are problematic is whether the Labor government's actually going to have a small business minister and whether that person will be in cabinet. There's been no announcement at the moment, and it's important, I think, for the small business community to see that the Labor government is taking small business seriously by appointing a minister to that portfolio, and secondly, having them in cabinet. It's the case, I think, sometimes that small business get very anxious when the Labor is in power because they don't believe they value small business very much, and this would be a good message to send to the small business community. The other thing I think the government should look at doing is to appoint a full-time dedicated small business commissioner to the ACCC. In the past, there was Dr. Michael Shaper, who was a fantastic small business commissioner with the ACCC, did a wonderful job, but when he left, the government decided not to appoint a dedicated small business commissioner. Rather, the obligations for that role were put on Mick Keogh, who has a number of other roles, including deputy chair of the ACCC and the chair and the commissioner responsible for agriculture. But he's got a lot on his plate. I think it sends a strong message to the small business community that the ACCC will have a designated small business commissioner. So that's all I had. I think it's interesting that there was so little policy actually in this competition and consumer law field that Labor brought to the election, but it's now time to really formulate a position on various policies. There's a lot coming up of interest. Clearly, the News Bargaining Code declaration or designation issue is coming up shortly, and then in September, the Digital Platforms Report will be presented to the Treasurer. So there are some big events. Which will, I guess, force the Labor Party to show its views about these issues. Given Andrew Lee's background, I think they're going to be very favouring of a highly interventionist approach in order to deal with concentration, common ownership and inequality in the Australian economy. Something that should be initiated, I think, by the government immediately is some review of the criminal cartel provisions, which are simply unworkable, and also improving the optics of the government in the small business community by appointing a minister for small business and appointing an ACCC small business commissioner. So that's all I had. If you have any questions about this presentation, feel free to give me a call or drop me an email. Bye-bye.